So, as a new administration prepares to take over, a look across the landscape of law in Nigeria, a landscape that is found wanting with fundamental lessons to learn. How can you have strong growth when you have weak legal institutions that cannot underpin its performance? No one can deny that the rule of law in Nigeria has to a certain extent not succeeded in one of its primary functions, which is to constrain the state and its agents. The results have been rampant corruption and economic contraction. But as Nigeria once again prepares to set out on the road to reform, if the promises of the politicians are to be believed, this, by implication, has to be the period when the rule of law can do the greatest good, as this country is trying to radically alter the course of its political and economic trajectory. So, as one legal analyst put it, it's time for silk gowns to stop groping knee-deep in technicalities, bills, cross-bills, rejoinders, injunctions, affidavits, etc. Mountains of costly nonsense piled before the courts, which so exhausts hope that you have to wonder whether there is an honourable man or woman left amongst its practitioners. So how can the legal landscape be made to be an integral part of the institutional setting in which we live our lives? How is the system to be reformed if there is so much that is rotten within the legal system itself? Well, let's find out what my first guest makes of all that. Professor Fidelis Oditah has been described as one of the most accomplished legal minds in Britain, Nigeria, and Africa today. He's King's Counsel in the UK and Senior Advocate of Nigeria, and holds 3 postgraduate degrees from Oxford. He is also president of the Nigerian branch of the International Law Association and runs a successful legal practice in both Nigeria and the UK. And Professor Oditah joins me now in the studio. Absolutely honored to have you here.
My pleasure.
Thank you very much indeed for coming in. And you have said in the past that the fundamental question that Nigeria's leaders must face is lawlessness if they want this country to develop. And by that, I presume you mean that Nigeria does not lack laws, but the rule of law.
Correct, yes. I mean, often the rule of law is bandied about, and it can mean different things to different people. But let me try and sketch out 3 possible meanings. The first is and everyone is subject to the law, which is the layman's understanding, all and sundry subject to laws, and that when there are infractions of the law, those infractions are detected, investigated, and enforced by prosecutors who are free from political influence, and before courts and tribunals, which are strong, independent, impartial, and honest. So that's one. You could also see rule of law as meaning that public power is constrained by laws, and the public officers and political leaders are accountable, and that no one is free to act with impunity. So if you want to analyze as a lawyer what those things mean, you could say the rule of law is both a norm of institutional morality, institutions, and also an overarching principle of constitutional law. So as a norm of institutional morality, the rule of law is concerned with the moral dimension of excuse me. Yeah. It's concerned with the moral dimension of public authority. And that's the principle of constitutional law. Of course, it has several applications. The central theme is liberty. But other than liberty, you want a system which is effective and which guarantees equality of access and enforces the law uniformly against everyone. And so when we say Nigeria is lawless, it's not because of want of laws. On the contrary, I think that Nigeria is over-legislated. They over-legislate everything. There's legislation. We've had constitution amended 5 or 6 times within a short space of time. We've had the Electoral Act amended any number of times. So it's not because of want or inadequacy of a legal framework. It's because of the impunity which characterizes the actions of the actors, both the political leadership, the public officers, and the citizens themselves.
Yes, so you do agree then that this issue of lawlessness and the rule of law may be the biggest challenge facing the new leaders who will be installed on May the 29th.
Absolutely. Absolutely.
And would you say, like some have, that indeed Nigeria's political stability and its key economic success may depend on its ability to develop the rule of law in a country such as this, where many argue that it barely exists?
But you can see the problems of the absence of rule of law with our democracy, or such democracy as we have. So democratic ideal involves 2 principles. The first is that the people entrust political power to the executive, the legislature, in accordance with free, fair, peaceful, and credible elections. And that there must be effective and fair means of resolving any disputes arising, and that requires the existence of courts which are strong, independent, impartial, and honest. So you cannot have democracy in either of those principles or ideals without a rule of law. So if you take the first one, if your institutions are weak, you've got police people who were there, people who were cutting away with ballot boxes, you've got INEC officials who were actively, instead of being independent, impartial umpires, were taking sides, and you've got courts which misinterpret the laws, you've got a recipe for confusion. So the rule of law underpins successful societies, not just political societies, it also underpins successful political economies, because every economy is underpinned by commerce, and commerce is underpinned by the fabric of law. And the rule of law itself talks about sanctity of contracts, sanctity of property rights. But when you act with impunity, you disregard property rights, you revoke, you ignore injunctions, and you do as you like, what you are creating is an entirely lawless society where everyone acts with impunity. So no one's behavior is constrained by any law.
That's a very interesting development, and I particularly find that aspect of it that has to do with economic development very, very interesting. I want to come back to that in a minute, but you have the unique privilege of being both a senior advocate of Nigeria and a King's Counsel. I keep wanting to say Queen's Counsel, but it is King's Counsel now, isn't it, in the UK. I wonder if you might make a contrast between the British legal landscape and Nigeria's legal situation as a way of looking at the discrepancies and the inconsistencies of the Nigerian legal system.
Well, the first thing is that in the UK, there is rule of law. There is an independent, impartial, and honest judiciary. And the UK legal system contributes about 5% of its GDP, which is huge. You're talking about 200 or 300 billion contributed by lawyers. And over 70% of the cases which come into the commercial court in England have nothing whatsoever to do with England. The 2 parties or 3 parties or 10 parties are foreigners. The reason they come is because they believe in the integrity of the British system. And it's there for everyone to see, no matter how high you are, if you infringe the law, it will be investigated, and if sufficient evidence is found, you'll be prosecuted. In Nigeria, in contrast, if you're big enough, no one would investigate you. A policeman couldn't stop you. And the reason he couldn't stop you is not because he knows, because he didn't know that he has power. It's because of impunity, which means that if he stops you, there might be reprisals. So he does his work, and he's punished for doing it.
Yeah, he's punished for doing the right thing.
For doing the right thing. So the system encourages impunity, encourages lawlessness, punishes those who try to adhere to the rule of law, and therefore turns everything upside down. So the contrast couldn't be more stark. With a system which is ordered and based on laws which everyone complies with. And because there's such massive voluntary compliance, it's easy to detect, investigate, and enforce against those who infringe. But here, it's a free-for-all. In some respects, you might even say Nigeria is a crime scene. Which one do you want to investigate?
Well, I have to ask you then, in that context,
Yes.
I mean, how have you coped with, because I mean, you kind of straddle the two countries. You do a lot of work here, and a lot of what you do here has to do with commercial law.
Indeed.
So I'm wondering how you have to deal with, because I mean, you talked about, you know, the law of contract as being essential in any country that wants to really develop and attract investment and all the rest of it.
Yes, but the enforcement of the laws, and I think this is important, the courts, with all due respect to them, have really not performed as well as I would have expected them to. Of course, I know that the courts are constrained in various ways: inadequate funding, poor infrastructure, inadequate training, the facilities are poor, the courtrooms are all cramped. But I'm afraid I don't agree that all those constraints have contributed to the mess that we now see in the courts. And you actually need a vibrant court system to be able to enforce contract and property rights. And one of the things that you have to do in a system of effective adjudication, any effective civil justice system, cases must be dealt with fairly and effectively so as to bring about practical justice. But where there is excessive delay, and some of the delay, in fact, you might say maybe 50 or 60% of the delay is caused by the courts themselves. So, for example, I'm supposed to be in courts this week, and someone has removed my case, but I've come from London to do it. And I come into Abuja, and they say my case, which is supposed to come up on Thursday, may not come up. And the case is impending for over a year, and I've wasted time and money, and I have prepared, and I've taken the risk of flying. And they say the judge or one or more of the judges has not returned from Salah break. So that is gross indiscipline at a senior level. But you can imagine the mindset of such a judge. I can't come back today, I'll come back tomorrow, but that impacts all the cases. So all these cases are adjourned. Some of them will be adjourned for 12 months, for 6 months, for 8 months. And when you combine that with the impact of the election, how the politicians have hijacked everything and given their own disputes priority, because once we have elections, everything stops. The election disputes are time bound. Therefore, if you're in court, if you're in custody unjustly, you'll be serving time which you shouldn't be. So you're imprisoned, incarcerated for no reason, because politicians want to have their dispute resolved. If you got rights to enforce, you can't enforce them just because of the politicians. But the courts themselves and the lack of correct work ethic means that the system has crumbled. So it isn't just the absence of infrastructure, which has to be acknowledged. It's a problem. There's no transcription and so on. But what have they done? It seems to me that we cannot wait for an angel Gabriel, a biblical angel Gabriel, to come and sort out the mess. The senior judges have got to take responsibility for what is a complete mess. And I think that there's a lot that can be done very cheaply. Of course, we know that the cases are too many, but part of the fact that we have overloading of cases is because of ineffective case management by the judges. And the inability to enforce to impose costs, because the court is a scarce resource. People can't just use and misuse it. But the courts encourage them. Very late applications for adjournment, very late preliminary objections. So you could file your papers today. Someone waits for 1 year, a day on the eve of a hearing, he files some response, and the court says, well, you know, we have to look at it. No penalty whatsoever. So it's impunity. If your behavior is not constrained by law, you have no incentive to act properly. Why should you?
Absolutely. It's fascinating listening to you talk, and I was going to ask you, for the benefit of our audience who may not be legal eagles,
yes,
perhaps you could explain exactly what is meant by the rule of law, but I think you've done that to some extent. But I'm wondering if you could use more examples, and you have, for instance, from the recent Nigerian election, or from whatever you might choose. In other words, what are the criteria, the correct criteria by which you might assess Nigeria's legal system? And you've already done that to some extent, but it's just that, I mean, it's, you know, it's brilliant listening to you do that analysis. So perhaps you could do a bit more of it. Well,
I mean, that's why I said, if you take the rule of law as a norm, you're concerned with the moral dimension of public power. But if you look at it as a principle of constitutional law, it has several applications. Well, let's look at the election. So to my mind, qualitatively, there is absolutely no difference between mandates obtained by force and mandates obtained by fraud. But maybe before I develop that, I need to remind our listeners about what I call the democratic ideal, that it involves two principles. The first is that the people entrust political power to the executive and the legislature. Entrust. And that entrusting gives legitimacy to political leadership, and itself underlines civil liberty and freedom of the people. It also ensures accountability, because it provides you with a reliable way to change the stewardship if you're unhappy. But where that process is interfered with, because institutions are weak, then what you have is an illegitimate, illegal political leadership, which is no different from military leaders. Because to my mind, there is absolutely no difference in quality between mandates obtained by force, such as a coup d'etat, or mandates obtained fraudulently through fraudulent elections. And that is very painful, because in both cases, there is no legitimacy, there is no mandate, there is no consent. The consent of the people is vitiated, in one case by force, in the other case by fraud. But vitiated it is. And that is a direct consequence of the absence of rule of law. So when you look at what happened in Adamawa, for example, if Professor Mahmood should go and declare results at 4 a.m. without having to take proper legal advice, assuming he didn't, they say he didn't, and he declares the results at 4 a.m. I know the returning officer declared, not him. Then the chap in Adamawa, knowing what the Constitution provides for, that it is the returning officer that announces result, he calls the press conference and announces the result. You cannot get more impunity than that.
Absolutely.
But that is a function or a manifestation of the weakness of institutions. So all our institutions, we've given the example of policemen standing idle when people are cutting away ballot boxes. We've even seen examples of policemen stealing the ballot boxes themselves, misunderstanding their role in society. We've seen the military people doing the same. We've seen the courts totally inept, weak, very partial, and corrupt.
And of course, it is that adjudicative procedure that must be fair. If you've got like all the things you've enumerated and it gets to that point, I mean, that's the last hope, as they say, of the common person.
Yes.
So, you know, that applies to judicial decision making, behind which lies the integrity of judges.
It is the courts that must enforce the rule of law. Yeah. That's why I said it involves two principles. The first is that you have the masses, the people, entrust political power through elections. The second is that you must have a fair and effective means of addressing disputes, whether they are political disputes, civil rights disputes, contractual rights, property rights. They must be fair and effective.
And obviously you don't see integrity, fairness and justice as underpinning the practice of law in Nigeria.
Well, I think that that's too broad a canvas. I think that's maybe too broad. In fairness, there are judges who are honest, impartial, independent, strong, and ethically sound, observing what you'd observe in England. They do their best. Unfortunately, they are few and far between.
Yeah, and that's what's worrying.
That is what's
worrying.
But
we've got a few minutes left. Let's try to proceed from the ethical roots of law, which you have so eloquently established, to economic consequences, which at first glance may seem rather like a leap. But it's actually not, because one of the universally acknowledged truths is that the rule of law, particularly insofar as it restrains the grabbing hand of the rapacious politician, is good for economic growth.
Yes, that's what I said at the beginning, that every economy is underpinned by commerce, and commerce is underpinned by the fabric of law. And the law has to be enforced, there has to be certainty, there has to be enforcement before independent, impartial, strong courts. And the difference between many countries which are developed and many which are underdeveloped is the rule of law.
Yeah.
But why would I come and invest
Absolutely.
in a place where my rights cannot be enforced? There is no guarantee. You might sign a contract today, someone tells you, well, yes, that's a piece of paper. It doesn't matter. Because they can disregard it, and then they tell you, as we have all been hearing recently, go to court, knowing that there is no fair or effective way of seeking and obtaining redress.
So in that regard, the inability of a country such as Nigeria to develop these effective ways of implementing the rule of law is, you could argue, the most important source of both historical stagnation and contemporary underdevelopment.
Correct. Because what do you find in Nigeria? If you look at historically, we've had a problem of rule of law. But even more recently, it's become worse. If you took a 20-year review, say from 1970 to 1990, you might even say the system was weak, but there were pockets of brilliance. But now when you look at it, and you say to yourself, you're looking for anything that can be described as fair. And that's why completely public confidence in the judiciary is eroded. And they tell the courts, they tell everyone, go to court. I'm sure the judges understand go to court means that go there, you won't get anything, because if the courts were effective, they won't be recommending people to go to court. And I feel ashamed for the judges, and I don't know what they feel for themselves. Because if I were in their position and someone is saying go to me, knowing that the outcome is predictable, they know that they can't get any redress, I'll feel really bad and I'll feel really small. And I won't even accept to be addressed as my lord or my lady. But unfortunately, they seem not to get this point, which is staring them in the face.
We've got less than a couple of minutes, which is rather a shame, having just experienced your great analysis there. But what would your advice be to a government that's coming in on the 29th of May about how fundamental and how important the rule of law is, and for the process of reform to begin, and perhaps where they should begin that reform?
The first is that the government must lead by example. The government must obey the law. And so when you go to government offices, they must be exemplary. You can't enforce what you don't observe yourself. That's one. They must. And it's a big challenge. There's no way you can move Nigeria forward unless you reform the public service. And the key reform is the rule of law. You must instill it. And then you then go to the courts and ask the courts, Why have you surrendered your powers to the political leadership? The Constitution gives you all these powers, but you seem to have surrendered them to the political leadership. Look at the Lawan decision. Look at Akpabio decision. Look at Fidelis Oditah. Look, one of the reasons that people come to lawyers, whether here in England or America, is that you'll be able to advise your clients based on principles which are clear and outcomes which are predictable. But the way that some of the Nigerian judges have completely muddled the law, created so many pockets of precedents which are incoherent, and you don't know where incompetence stops and where other considerations begin, and it's really unfortunate. So it must start from those public servants observing the rule of law, doing what is right, not hiding people's files, even being courteous. Because when you look at Nigeria's public officers and political leadership, they're lords, they lord it over everyone, and they want to be revered and respected, whereas they're supposed to be public servants. So there's a complete misunderstanding of the relationship between the political leadership and the people. And it's because elections are not credible, there is no system of accountability.
Prof, I want to thank you very much indeed. It's just superb, ranging through your experience by way of communicating with you. And Professor Fidelis Oditah is a King's Counsel in the UK, Senior Advocate of Nigeria, holds 3 postgraduate degrees from Oxford, and is the President of the Nigerian branch of the International Law Association. Thank you very much indeed.
Thank you.